Awesome. You'll hear the recording in progress, but just want to thank everyone so much for joining us for our moderation, our amazing moderator and our panelists. This is actually the kickoff for the Responsible AI Institute virtual event series. We're going to be holding these monthly on kind of hot topics, things that are important to our community and to our members. My name is Alyssa Lefebvre-Schkopitz. I'm the head of Global Partnerships and Growth. We're super excited for this conversation. Obviously, the EU AI Act has been a huge topic for everyone in our community, and getting all of these amazing panelists and expertise together to kind of share what we know today and where this is going is key. During our conversation, feel free to put your questions in the chat. We'll try to address them if we have time or even in the chat. From now, I'm going to give it to our amazing moderator, Krystal Hu. She's going to introduce herself and our incredible guest panelists for today's event. If you don't know Krystal Hu, she is a tech correspondent at Reuters with a focus on venture capital, startups, and AI. She's been writing about upcoming AI startups, breaking stories on funding in the sector, and covering broad implications of technology for many, many years. Previously, she has covered M&A at Reuters and technology at Yahoo Finance. So we're delighted that she's here to moderate this discussion. Krystal, I'll pass it to you.
Thank you so much, Alyssa. Thanks everyone for joining us. We're really glad to have the opportunity to talk about AI, specifically on EU AI Act with our great panelists who come from different sectors within the AI and tech space and can bring us a really diverse interviews, perspectives on what's going on in the space. And as we talked about earlier, the space evolves so fast. With the news just happening last week alone, probably will have a lot of content for us to catch up on. So I would have the great panelists to give us a brief background about their experience and expertise in AI. So Adam, I think we'll start with you.
Sure, thank you, Krystal. Adam Ruttenberg, I'm a partner at Cooley. I've been working in the AI space for almost 20 years now. Even though AI has just become the flavor of the day, if you will, because of what's happening with large language models and generative AI, actual machine learning and AI has been around for a long, long time, and we've had a number of clients work in that space for a very long time.
Hadassah?
Yes, thank you so much, Krystal. And it's great to be here. I'm Hadassah Drukarch. I specialize in tech policy and regulation. I'm currently a fellow at the Responsible AI Institute, really helping and contributing together with our great team to the development of the responsible AI practice. I'm also the founder and director of the Law of Tech, which is an information service group that aims to bridge the communication gap between law, policy, and tech professionals. I'm really excited to be here and to share my insights and thoughts about the topic of AI regulation. So thanks.
Lucía?
Thank you, Krystal. Thanks everybody for joining. I'm Lucía. I'm part of the policy team at Credo AI, where it's a AI governance startup that we support companies from Global 2000s to small and medium-sized enterprises and startups to adopt responsible AI practices. My background in AI policy is also related to social media and trust and safety and issues including elections, misinformation, and all of the good stuff that happens on the internet. So very excited about this conversation.
Yeah, suffice to say it's going to be a busy year for you on the election and disinformation stuff. So that's really great to see everyone's little bit different background and expertise in AI. And I think will be helpful for our readers to understand, or our participants today, to understand the broader kind of implications of the EU AI Act. But let's start with the basics. Even as a journalist who follow the topics, I see the headlines all day and it seems a very lengthy process. And for people who are operating to space, maybe Hadassah, we'll start with you. Can you give us an overview of what exactly EU AI Act is and how likely it will impact practitioners in the AI space?
Yes, definitely. You're very right, Krystal. It's been quite a lengthy process, I would also say. We really started back in 2021 already, almost 3 years ago, with the proposal for an EU AI Act. The idea of the act is really to balance, on the one hand, innovation in artificial intelligence, which we cannot deny is extremely important and will bring tons of benefits to society in many different industries. And on the other hand, also acknowledging the risks that these technologies may pose depending on the context, the application. So we're trying to, not me necessarily specifically, but the European regulators are trying to balance these two out through a set of very comprehensive rules. Now, we've gone through this whole process. We're now really, I would say, past this turning point where this piece of legislation or this regulation is really going to turn into an official piece of legislation. We recently had the adoption by the committees of the European Parliament. We're now really waiting for April 2024 for the final bits and pieces to come together and for the act to turn into a real piece of legislation that will be enforced in a number of years from now. So I'm sure the other panelists also have some thoughts on this, but that's essentially where we are right now.
Yeah, so it sounds like we're finally approaching the final stages and getting a concrete idea how this will be impacted. And Adam, I know you spend a lot of your time advising companies, both in the US and abroad, who could be impacted by this new piece of legislation. And now we're in just kind of a transition period. What are you hearing from like founders or investors about having their companies to be compliant with the EU AI Act?
Well, so Chris, that's a good question. I mean, I think what we're seeing is really a couple of different things, right? People are taking a hard look at what the EU Act is, and again, what the AI Act ended up doing is taking both a horizontal approach, a risk-based approach, but also somewhat of a vertical approach, right? They categorize different types of AI, and they have different rules for if you fall into one bucket versus the other. Some of those are risk-based approaches, high risk, low risk. Some of them are more vertical, general purpose AI, right, as a category, right, that they have just sort of separate rules for. And so the first thing that people are trying to do is figure out what bucket do I fall into? And then based on that bucket, then they're trying to figure out what decisions do I have to make? Because the AI Act has some interesting attributes. For example, if you're in a general purpose AI, one of the things that you have to do is disclose all your training sources. Document and disclose all your training sources. And what we see in the US is there's been a series of class action lawsuits against LLMs, right? Whether there's the lawsuits against Llama or Meta, the lawsuits against OpenAI. There's a series of lawsuits about the training data. And the truth of the matter is we don't know what the outcomes of those lawsuits are going to be we won't know for years, right? So we're in this gray zone. And at the end of the day, what people are concerned about, both founders, investors, and pretty much everybody, is if I have to disclose all my training sources publicly, is that just an invitation to get sued? Because very rarely do we see someone building an AI solution just for the EU, right? No one builds a product just for the US anymore, or just for the EU. And so the question just becomes then, do I deploy my solution if I fall into one of the buckets that require disclosure of training data sets in the EU right now, because that's an invitation to be sued, or do I wait, right? And part of it's also timing, right? Because not all of those, even though when we get to April and the AI Act becomes effective, there's still a delay in when certain provisions become effective. They range from 6 months to, I think, 36 months, right? So we have some time to figure it out, but I think people are trying to take a pretty careful look at, until I know what these class action lawsuits look like, do I wait to deploy in the EU? It's going to have a little bit of a chilling effect as people are trying to figure this out, because they don't want to be sued. The cost of litigation is high, the outcome is uncertain, and right now we know that based on the class action litigators, if you disclose it, you're likely to get sued.
Yeah, I think that's injunction of the lawsuit will take a while to play out, but meanwhile, this is going into effect. So people have to kind of make decision now about what to disclose and if they're going to disclose about their training data. And this is for model developers specifically, or does it apply to applications builders?
It also applies to applications, and really, obviously, if I'm just an application built on a foundational model, I won't know, right? Unless the foundation model tells me. But that's why the AI Act requires certain foundational models to disclose that information so that I know, right? But ultimately, again, until we have a better sense of the outcomes or the likely outcomes of some of these class action lawsuits, people are just going to bring suits against anyone that they find to have deep pockets, right? That they can bring lawsuits against. And so both the way the AI Act works and the way the US legal system works, right, which is where this is sort of really playing out, we expect that if you disclose a bunch of training sets from data that you didn't license, right? And so there's some LLMs and foundational models and other sort of engine-based technologies, right, that allow people to build applications on top of that built it with just licensed data, although those are relatively small and those are generally not the big LLMs. Right, and so for the big LLM and for some of the big LLMs, right, they're already being sued, right? So their risk analysis is a little bit different. But it's those second order LLMs or the newcomers who are struggling with this, or the companies that are building their own LLMs for their own applications that are struggling with this, and that's where they get into both the buckets that they're going to fall onto into the AI Act, but also what we're seeing is the influence of the AI Act, much like we saw the influence of GDPR against U.S. legislation, right? So we're already seeing in California, some legislators have already introduced provisions around disclosure of model training. Again, don't know if they'll ever become law, not even been voted on yet, but there's talk about those sorts of things, and we're going to expect that talk to continue until things sort of settle out here. And I think that's the challenge of the AI Act, not just in how it applies in Europe, but how it influences legislation across the board, across the world.
Yeah, we'll definitely circle back on that topic. I want to also bring in Lucía because you are on the front row seat with working with a lot of companies, helping them thinking about how to be compliant with regulations, including the upcoming EU AI Act. Besides the training data issue that Adam talked about, what are the other top concerns that this new legislation may bring to AI startups you're seeing?
Well, Adam alluded to this a bit. I think in general, there's not a lot of enterprises and organizations that are going to fall within the general purpose AI definition, and more so that they're going to fall within the systemic risk category within that. And so in order to know if you're in that category, you have to submit a code of practice. And those codes of practice need to be submitted within 12 months of the AI Act entering into force. So that actually puts us in mid-2024. That's actually not a long time. And so I think the concern is like, well, at least what are the things that I can start doing now to at least know what I'm exposed to if I fall within the category of systemic risk. But being said, like the large majority of companies are gonna fall more so, are trying to do an analysis around which risk category they fall into, right? Like we see that most enterprises that are using AI, they are downstream users of the AI and not necessarily within the general purpose AI definition. And for them, it's more a calculus around, is my system high risk? Because that is where the meat of the text is in terms of the requirements, which are pretty hefty and include a set of things, starting with having a quality management system in place. And within that, there's different things that fall through, including having human oversight, for example, or eventually getting a CE marking that says that you've actually done all the things that the text says you should do if you fall within high risk. So I think those are the main concerns. How do I even begin to assess if I will be considered high risk? Because if so, then there's a lot of things that enterprises need to start doing now. And the 24 months for high risk enforcement to begin, which is mid-2026, again, seems like a long way out, but if you do fall within that category and can slip in and out of that category, right? It's not a static category. And also 8 broad topics had been identified in Annex 3. But that being said, there's also room to add additional categories into that. And I'm happy to get into details if people are interested.
Yeah, we'll definitely kind of get into that. And I think some people already also ask about practical kind of solutions for being compliant in those circumstances. And Hadassah, I know you spend a lot of time researching policies both across the pounds and in Europe and within the US. And, in the past 2 years or so, we have seen this global race of regulators trying to regulate the AI industry and, the new technology that being populated by ChatGPT. And what are you seeing the differences between maybe some of the regulations in the US, like the executive orders, compare to the EU AI Act we're seeing?
Yeah, that's a very good point. There is indeed like a kind of a race going on to regulate AI. I think as a point of departure, what's important to note is that the ethical discussions that kind of underpin this race towards regulation are, in broad lines, maybe some details on the details, maybe not, but in broad lines, they are all the same, essentially. So we're talking about ideals that we want to achieve with this regulation that is essentially the same across most of the countries, like in the West, I would say. So between the EU and the US, the core is the same, but I think the way the format and the shape is different. So I think there are essentially 3 elements in which the approach towards regulation within the EU and within policy development and regulation within the US differ, and that's on the topic of the scope. I think the actual approach and enforcement. So I think what we see in the EU right now, and I think the EU has taken pride in the fact that that's really what they stand for, to create these very comprehensive, detailed pieces of regulation that in essence provide detailed provisions for organizations to understand how they should comply with these basic principles and values that we have. That is what the result is of this EU AI Act. So it's a really comprehensive document at this point in time. There are clear provisions around high-risk systems, prohibited systems, limited and low risk, especially around transparency. And then you have enforcement with very hefty penalties and clear impacts in the case of non-compliance. And we see that in the US, there are a lot of discussions about how this type of policy development, this regulation, is impacting across the Atlantic Ocean. I think it's inevitable that isn't the case. So what we're really seeing is that the US is developing more of how I would like to describe it, a kind of like a guidance, a strategy of how to approach AI with clear directions to, for instance, federal agencies and other agencies to develop more clear practices rather than setting out very clear provisions and requirements as to this is what these organizations or these system builders should do. And enforcement is also different, I think, in both contexts.
Yeah, Krystal, if I could just jump in on that. Hadassah, I think you're 100% right. It's interesting, the DOJ just this week sort of put out a statement that they said, look, from an enforcement perspective, let's keep in mind one important thing, which is in the US, price fixing is illegal. If AI assists it, it's still illegal. Discrimination is still illegal. If AI does it, it's still illegal, right? Their point was, and they went through a whole set of examples, right? We have a set of laws in the US that prohibit a whole set of activities. And what they've said is, look, whether you do it with a human being or you do it through artificial intelligence, it doesn't change the fact that it is still illegal, and we're going to enforce it as such. So you're responsible for the actions of your implementation of artificial intelligence, right? And that's the FTC has said that, the SEC has said that, all the agencies. That being said, through the White House executive order, the administration has said, look, we should give better guidance, right? And what we expect. And so we see some concepts that mirror some things in the AI Act, like the concept of red teaming and the concept of having the right policies and procedures in place, as Lucía was sort of talking about, which again requires people to get ready to be able to do that. And sometimes that's harder than you would think because you don't have all the data right now, right? So and how you do that red teaming is sort of unclear and things like that. So I think they're looking to give industry some kind of guidance, but guidance that sits below the laws, because they don't plan on changing the laws, the fundamental laws, and saying somehow we're going to treat AI different under these laws. Their view has been pretty clear in the US. Whether you do it sort of with a person or you do it with AI, you're responsible for your AI, and if it does something illegal, you're responsible for that. Which is going to lead to some interesting outcomes. There was a case just this week or last week, where there was a chatbot for, I think it was Air Canada, that offered a bereavement fare, right? And that just kind of made it up. And now Air Canada owes that individual the bereavement fare because they didn't want to give it to him.
Yeah, I remember that case. Is kind of interesting. I think Air Canada fought really hard for, I think it was like $1,000 compensation for that. But I understand they probably did not want to set a precedent for that. But it's really interesting to see that hallucination sometimes do create problems, that no matter if it's, you know, a representative of your agent, the organization still need to be responsible for it. So we have seen a lot of good questions on like the framework. This panel is focused on the EU AI Act, but apparently people are seeing, you know, all the frameworks in different legislations and different jurisdictions, and people are confused. And so what do you guys see any expected like efforts of a unity in terms of a united like standards to regulating this industry globally, that one standard people can just follow and they're good? What are you seeing in terms of having like one standard in terms of regulation in AI? Maybe we can start with Lucía.
Yeah, and then Adam, please go ahead. There's definitely convergence, right? Around certain elements that enterprises and companies should start putting in place, regardless of what risk category you're in. I think if we segment, it's helpful to segment between LLMs, general purpose AI, as stated in the EU AI Act text, and downstream users of AI, which if they want to do a modification to the system in the EU AI context, they are then considered providers, right? And then certain additional requirements come in and are triggered because of that. And just even defining like what is a substantial modification. But to go back to your question, we do see certain standards emerge, like ISO 42001, which share a lot of those common elements around just having a risk management framework in place. And with that, it comes having certain data governance requirements, for example, and having some benchmarks to which you can assess your different AIs. I think those are really good foundational elements that people need to start thinking about. However, one of the things that still needs to be seen is the use case and sector specific application many times of those, because that is really going to define what is considered high risk, quote unquote. So again, we do see that convergence of like, okay, the use cases that we need to be regulating are the high risk ones, but they can be very different depending on whether you are a developer, a deployer, and if you are deploying it in, let's say, a financial context, or if you are deploying it as a process to enhance a business function, for example.
Yeah, I think what Lucía said is exactly right. But with the overlay, I'll just answer bluntly. No, we're not going to see some global standard, right? Because we don't see global standards for anything, right? I mean, it's just that is the nature of sort of individual countries and how we all act. And AI is a horizontal technology that has lots of applications, as Lucía was alluding to, right? And so each application will be regulated by each country in its own way. There are common things that you might find, much like you did in privacy, where you find a privacy standard that's been tailored to AI, that's an internationally recognized standard. You might see that. Certainly a security framework, there will be multiple competing ones like the NIST framework, but you may see global standards around security around certain AI things. But are you going to find like something like the AI Act that'll just be a global law? No, you're not going to see that.
What are the kind of willingness level you guys are seeing in terms of private enterprises to be kind of proactively prepare for regulations like this that may take years to go into effect, and while the technology itself is evolving so fast?
Yeah, I mean, look, everybody's thinking about it. Everyone's trying to figure out what to do. I think, Lucía, you pointed out earlier, right, that it's not that easy, right? Like, so especially if you've been building your application, or you've been building your general purpose AI, or you've been building your sort of application on top of someone else's general purpose AI, you may not have all the information you need to comply. And so now it's a little bit of catch up. And that's one of the problems that I think people are going to run into with the AI Act because of the timing, that it's not going to be as simple as some people would like it to be, right, to comply with some of these things, because you may not have all the information. You can put policies in place, but can you actually go back in time and figure out what you did a year ago, 2 years ago? Maybe, maybe not. And so that's, like, in my mind, that's one of the great unknowns. And I know a lot of our clients are struggling with how, they want to comply. No one doesn't want to comply, but it's a question, can I comply? And they're trying to figure that out, right? And some of it's going back and recreating history because they didn't build their solutions for those that exist. For those that come next, that come now, a little bit easier. But for those that were building their solutions 5 years ago, may not be easy because they didn't build them with these regulations in mind, whether they're the AI Act or the things that are happening in the US or elsewhere. And so now it's a little bit of a scramble.
Lucía, Hadassah, any thoughts there?
I'll hand it over to you, Hadassah, if you want to step in next. I wanted to say that what we are seeing is that regulated sectors in general are better positioned, like companies within regulated sectors. So when you think about healthcare, finance, banking, and such, because at an organizational level, they already have some structures in place to actually make sure that they're investing the right. It comes down to sometimes a people investment to begin with, just to start even identifying what are all of the AI use cases within that organization, which can be massive. From my experience in terms of algorithmic recommendations, for example, we tend to think about the algorithm, but in reality, there's hundreds of algorithms that are feeding one recommendation system. And to Adam's point, going back and identifying, like, even which engineer owns those models, right? Have they been maintained? How do they interoperate within each other? That is actually very challenging. This being said, again, back to regulated sectors, there's a bit more of a compliance layer that is embedded within the organization. And I think that's something that a lot of organizations are going to have to move towards, because otherwise it's going to be more costly in the long term if they want to piecemeal their approach to I mean, not even compliance, right? It's just even to understanding and managing their AI use cases.
Yeah, I'm also happy to add to that. I totally agree with what you said, Lucia, about the kind of like the distinction between those markets that have already been regulated for a long time, that have the resources and the infrastructure to ensure compliance. But I think indeed the compliance is one thing, right? It's important to understand that compliance, despite the fact that it's extremely important, shouldn't become like a check the box kind of exercise. That's kind of what like these discussions tend to kind of result in. But I think at the end of the day, one very important element in this kind of unknown space in a way is also the intention. So when we like take back a step, I think it's extremely important for organizations to understand where are they in terms of their organizational maturity, where do they stand as an organization in terms of the policies, the people within the organization, their understanding of these laws. Are they acquainted with like the terminology, the structure, the concepts that we are talking about in this kind of like policy regulation framework, and start from there really, because if your organizational maturity or organizational understanding of what is going on isn't in order and you're immediately heading to compliance, like I want to make sure that everything is in order in terms of high risk systems, transparency requirements, data quality requirements, you're going to kind of run into some issues along the way, I think. So I just wanted to add that as well.
Yeah, to follow up on your point on regulated industry, we actually have a question from our audience that if you guys expect any additional legislations coming for Gen AI, specifically in high-risk industries like healthcare, besides EU AI acts. What do you guys think?
Yeah, well, I mean, the short answer is yes. And I think it'll be good. It'll be good, and I'll give you a really easy example. So, and we've already started to see some of it. For example, the FDA, if you go back 20 years, there were AI application in the diagnostic space, which the FDA wouldn't approve because they didn't understand why the AI was making the decision it was making, right? It was a black box. And they were proven through clinical trials and otherwise to be highly effective, yet they still couldn't get FDA clearance or reimbursement approvals for Medicare, Medicaid, things like that. we know based on the White House executive order, we know based on what the FDA has already done in AI and some of the regulations and clarifications and guidance that they're giving, that they're moving towards providing better clarity and better regulatory pathways, which will actually enable the use of these technologies to that again, to Lucía and Hadassah's prior point, that are already sort of safe and with the right intention and do the right thing and are proven, but they'll be able to get them to the market in a way that they couldn't 10 years ago because people didn't understand it. So I think one of the really good things that's happened, not just because of the AI Act, but because of the attention to AI generally, not just generative AI, but AI across the board, we're seeing more attention paid to say, look, this actually can be a sort of a transformational technology, and we need to enable it, again, in a safe, appropriate, ethical way, but we do need to enable it, and we need to be able to understand it and provide some guidance around it. And I think that has already started to happen and will continue to happen going forward, certainly in these regulated industries where perhaps it was a little unclear whether you could do it or how you could do it. I think that guidance is going to come, certainly in the United States.
And if I may add on to that, like already in the executive order, while it is focused on federal agencies, I think it's reasonable to expect that there's going to be a trickle-down effect, because if you want to sell into the government, right, there's already going to be certain things that you're going to be required to do. And just by the power of the purse of the federal government, right, there's enough incentive, I'm sure, for some players to start thinking about, okay, what do I need to do in order to make sure that I am complying with the forthcoming guidelines that will be issued by Health and Human Services, for example. And also, as we've seen in other sectors, again, like financial sector, the CFPB has put out circulars clarifying that their existing regulations apply to AI. So to Adam's earlier point as well. So I think we can expect that to happen in the US, where existing frameworks are just gonna be applied to AI, especially when we're thinking about outcomes-based regulation, right? So it's like, it doesn't matter what the tool for you to make a decision around diagnosis, it's more making sure that it's fair, transparent, et cetera, and aligns with those values. So I guess the short answer is yes.
Great. So we have talked about companies who are developing their own LLMs. We have talked about highly regulated industries. And then there is also a big category out there, which are enterprises using kind of, on the shelf type of AI service provided by cloud providers or AI labs like OpenAI's of the world. I think one of our audience also asked this questions. If you are one of the many organizations who are using the third-party vendor solutions, can you rely on the terms or standards and conditions that they set up? What do you need to do to kind of address the gap between their terms of services while being compliant with the new regulations? Maybe we'll start with you, Adam.
Yeah, no, you can't rely on that by itself, right? Because the whether it's OpenAI or using Llama or any of these sort of general purpose LLMs to build on top of, they're general, right? And so by their very nature, they don't account for the things like Hadassah and Lucía was just talking about in terms of the regulated industry. If I'm building a health-based application, they don't prohibit that, but they don't necessarily tell me that they're fully compliant. So you still have to build your own compliance regime around your application. And again, it goes back to the principle, at least in the United States, it goes back to this principle of, look, it doesn't matter whether you did it with AI or you did it with a person or you did it with some other piece of software. You're responsible as a company for the outcomes for what you're doing. And AI isn't really going to change that. It makes it easier, it makes it faster, it can do phenomenally wonderful things, but ultimately it comes with its own dangers as a result, which is now you just have something that's really fast and really good at doing things that you need to control and put guardrails around and make sure it complies, right? It doesn't, if it's making housing decisions, it doesn't discriminate. If it's making credit decisions, it doesn't discriminate. It documents its work the same way a person would be required to document its work. And so there's a lot of work that you're going to have to do as an application developer on top of whatever foundational technology you're using, whether it's machine learning or generative AI or otherwise, that doesn't change. And in some places, it's going to make your life a little bit more complicated. Again, at the end of the day, it could be transformational. It could be really good. But ultimately, you're still responsible for whatever tools you're using and the outcomes of those tools.
Oh, go ahead, Hadassah.
No, I just wanted to add to that what you just said, Adam, about, it may in the shorter term make things a little bit more complicated. But I guess like the real idea behind these regulations in the first place is to ensure that you kind of know what the risks your systems are posing, and that you put in place the measures that you need to ensure that, when the authorities actually come knocking on your door, you know what system you're using, you know what governance mechanisms you have in place. So I think it's really important to stress what you just said, Adam, that you're responsible to put in place these measures, but also to really know what you put in place in the first place. And that also requires understanding what is required from you as an organization working in this field. So I just wanted to stress that. I think it's that's like key, I think, the key point or takeaway, perhaps even, from this entire, discussion on this topic. Sorry, Lucía.
Yeah, to add on to that, I think that's the key element where transparency across the AI value chain needs to be mandated, because right now the developers don't really have incentives to provide those disclosures to downstream developers. And downstream developers need that information in order to then understand, okay, if I fine tune this model, or if I layer on top of it my own controls, then what is that incremental risk? And being able to do that last mile or last kilometer, I guess, depending on when you're calling from, but of AI governance, you really need to know like how the foundation model, like what guardrails they have already put in place. And this can be done through data set cards, model cards, algorithmic impact assessments, where of course there's the element of, how much you want to disclose and how do you, if you want to remain competitive. But at the same time, at least at Credo AI, we believe that there is certain information that can be disclosed to your downstream users so that they themselves can layer on their own governance mitigations depending on that specific use case. And that is an area where the EU AI Act, through the codes of practice, is aiming to kind of force these developers to actually provide that information.
Yeah, I think that transparency is actually definitely kind of up to debate now. There's a lot more pressure, even from like the source providers, which is a foundation model themselves, have to offer more transparency for people who are using their models. So hopefully we'll see more of that down the stream. I do want to ask about innovation, because we are talking about this great, groundbreaking technology here, and the innovation's relationship with regulation and on the companies themselves. On the company level, I'm curious if you guys are seeing how companies kind of balance their resources in terms of, putting, all the dry powder and, talents that they can get to develop, new products and new technology in AI versus, allocating some of the resources to be compliant and to come up with this like strategy or resources and to be futurely potentially compliant, or even to kind of make a trade-off and think about like, do I just train with any kind of data I can get, like without worrying about the transparency for now? How are you seeing companies balance that in this race? Maybe we'll start with Adam.
Yeah, sure. So I think, look, there's different companies that fall into different buckets, right? We have companies who are building foundational AI technologies, right? And they take one approach. We have companies that are building applications to be AI-based companies. They take a slightly different approach. And then we have other companies that just want to use AI to help their business, right? Could be a law firm, could be, just sort of a retailer, right? We might be using a chatbot. And they take a different approach, right? So if we take those three buckets, right, for the retailers, the law firms of the world, we have to look at our use of those tools, because again, we're responsible for what the output of those things are. And right, there's lots of cases in the US, as an example, where lawyers didn't check the work of some generative AI like GPT, and then they got in front of a judge and it showed that judge false cases because of hallucinations or bad prompt engineering, and they were sanctioned. And some of them lost their jobs, right? That's just because they weren't careful in how they were using it. They didn't put their right, again, it's not even a technology problem. They didn't put the right policies in place. They didn't follow the right policies of human review and other things that they should have done. So you have those that are kind of looking at it that way. And you have on the other extreme where you have the foundational technologies, right? That those people, right, are, they're struggling a little bit right this second, trying to figure out what the next step is, because to continually evolve and make more powerful these, for example, LLMs, you need more and more data. And because the law is unclear whether that use of some certain types of data is fair use or not, right? That's what these lawsuits are about. And we're not going to know the outcome of those lawsuits for a while. They're in this gray zone of a little bit of a wild, wild west, and they're making risk assessments. And each company is going to make a risk assessment a little bit different depending on its risk tolerance and the risk tolerance of its investors. And so we're seeing different people make different decisions around that. And then there's the group in the middle, which is probably the largest group, which are those building applications on top of some of these foundational models, which we've talked a lot about. And what I think is what's starting to complicate their lives is they may not be building something on top of just one foundational model, but they may be stitching together multiple LLMs or an LLM with a machine learning model with something else, right? And that further complicates their lives, and they're trying to figure that out. And I think those it's less about what data can I acquire and how do I acquire that data, although there's certainly an element that everybody's dealing with on that front. But it's also how do I put some guardrails in? How do I do technical guardrails? How do I do red teaming? How do I ensure that I'm compliant, right? And the problem with that is, and I've seen this in some of the comments, right, is there is a cost of doing business that is more than just the cost of acquiring access rights to the underlying technology now. But because this is complicated, because this is a little bit of a wild, wild west for the next couple of years, because we don't know where all the regulations are going, there's not just a risk cost, but there's a compliance cost that's going to be an overhead to a lot of these companies that they are acknowledging. But at the same time, right, we're still in an environment where AI is the flavor of the day, much like blockchain was 3 or 4 years ago, much like, right? And so we're seeing that people still want to use it because if they don't use it, they feel like they're being left behind.
I think of this as like the privacy by design movement, right? Like before GDPR, everybody was trying to layer things on top. And then eventually, like if you actually embed it to your process, then it becomes by design. And then it's actually a bit of more of an upfront investment, but then you're not dealing with the after fact of having to deal with how did you handle certain data within your organization. We started to see it a little bit in terms of safety by design, right? Because of the DSA and again, like the Europeans adding a lot more pressure to a lot of these companies, and seeing one of the comments around like social media not being regulated enough. I think in the same way, trying to tip the scale towards having AI governance by design is something that for many is going to be part of that risk and cost calculus, where then that is an investment that goes hand in hand with innovation. And I do think that like those companies are going to be the long-term winners, because rather than like patching your way through the failed or the bad story, the bad press, and trying to patch that is actually many times devotes a lot of resources from the company to do some risk mitigation after the facts. And you are not going to be able to solve for all of the problems. However, if you do have those mechanisms in place, you can actually even reputationally protect your brand when you said, I did follow all these things and this happened. And even that can be a learning rather than a fault where you just do the things that you needed to be done just when you're called to Congress to testify, right? So I think that's a scenario that we want to prevent here.
Hadassah, to bring your academic expertise, how are you seeing like the regulators and lawmakers themselves making kind of compromises or going back and forth between regulating this upcoming technology but not stifling innovations in terms of the final tests of those regulations?
Yeah, that's that is the question. I mean, we've been seeing. I also just wanted to quickly touch upon one more thing, by the way, that Lucía and Adam just said. I think one more thing that's very important, and then I will definitely respond also to this before I forget, is like this the importance of alignment within an organization between the different teams. Like I've at the Law of Tech spoken to quite a number of organizations across like all those different parts, those different approaches that Adam mentioned at the start. one of the problems that they're facing is this type of alignment between, on the one hand, legal and compliance teams, data protection privacy teams, IT and security, research and development teams. Like, how do you bring all those different perspectives together, and eventually also executive management, right? Where do the resources go to? You can only understand where they need to go to if you at least ensure that you're all on the same line, or at least open up this discussion to understanding where each of these different teams stands and where each of them believes, the important points or the important attention should be directed towards. So I just wanted to add to that. And then in terms of the approaches of the approach of the European regulators, I think it's extremely difficult, right? Because you're dealing with an extremely fast-paced environment. We all know the famous pacing problem, or the Collingridge dilemma. Technology evolves way faster than regulation does. So it's extremely, extremely hard to create a framework that is adequate. I know that in the chat there was also discussion or a question about, is this piece of legislation future-proof? That's going to be a question we all need to wait and see, what's going to happen. The idea is like legislators are creating a framework that is technology neutral. So the idea is that as technology evolves, it should still apply to these new developments. But the problem is we only really know what is going to be reality with this legislation once technology continues to evolve and once application issues arise. So I think that with opening up the debate to the public, involving stakeholders in the creation of these pieces of legislation, legislators are trying to make sure that these pieces are as adequate as possible and aligned with the reality. But it's impossible to make sure that they are 100% future-proof.
A reminder to our audience that we have about 10 minutes left in the conversation. So I've seen some great questions coming in. And if you have more, please type it in the chat or the Q&A. And Hadassah, just to follow up on that point, I think I've heard a lot of discussions on open source software and models and how they're regulated in terms of, how when EU Act or executive order in the US and the impact on them. You have seen arguments from both sides. Can you maybe decode a little bit the final text and how the final regulations will look like for the open source communities or people who are using open source models?
Yes, definitely. No, I think we've seen this discussion on open source, especially in this general purpose AI scene, right? And the requirements that are posed to those developing this. I think still, in my opinion, but I would be very curious to hear, for instance, from Adam, like working more in practice and litigatory side of things. I think a lot still remains unclear in a way, like how this is going to play out in practice at this point in time. There's like a tiered system, right, with requirements for specific open source approaches. But to me at least, reading the text, a lot still remains very unclear, as in like, what does this mean for them? I think it's confusing for those who develop this also. I mean, I listened to an entire panel on exactly this topic, and I think the conclusion of that was there is no clear direction at this point in time. But I'm curious to hear from you.
Yeah, no, I think that's right, Hadassah. I think so the AI Act, when you talk about like general purpose AI, they did say, hey, look, if it's an open source model, not all the requirements apply, only these two requirements apply. But even when they say that, I think it's a fundamental misunderstanding of open source software, which creates a problem, right? Because that works if you have a single entity that's promulgating the open source software, but a lot of open source software is community developed, right? And then who's responsible for making those things? Because there's not one person that you can say you own this project, right? There may be hundreds or thousands of people over time that contribute to the project. It's unclear who's responsible to make the filings. It's like, because it's not a company necessarily in all cases that's doing it. Like obviously in the case of Llama, it was Meta that put it out, but over time, again, there could be other open source models that are more community based and community developed. And at that point, we really don't have a good answer or good guidance from even under the AI Act as to how to comply, who's responsible to comply, who gets fined, what's the fine, because there's no revenue, it's open source. So like there's a lot of things in here that kind of don't work. And it gets back to the point of when we think about future proofing legislation or trying to be technology neutral, sometimes I feel like some of the people who regulate don't fully understand what they're regulating. And so they make statements under assumptions, and I think this open source is a good example of it, that may not be true. And so like we just don't, I don't think they contemplated community-based development as an example, right? And what they don't want to do, I don't think, is discourage community-based development, because there's all sorts of good things that come out of the open source movement and community source development. But if the position that ends up getting taken when this gets clarified, which eventually I believe it will get clarified, is that anyone who contributes is responsible, then that's going to kill open source AI, right? Because then people won't contribute because they don't want the risk, because they have no ability to necessarily do it. So, and if they say, oh no, if it's community developed, none of the rules apply, well then that's just going to be this giant loophole that everyone can drive a truck through, that will be what people use to get around the regulation. And that's not what people want either. So I think it is a problem, Hadassah, and I don't think we have a clear answer to it at this point.
No.
What I think they try to do is like, hey, okay, there's the model, and if you modify the model, then all the rules apply, right? Again, it's not airtight, but that's the text, again, I agree with Hadassah, is not clear. That being said, they were trying to balance and not have a great answer, right, to like the open source versus innovation discussion.
We've got some questions on the EU AI Act on different countries. I'm gonna consolidate a little bit. Do you guys see like in different country will interpret the EU AI Act differently within the EU, and how would that apply for different enterprises operating? And then more broadly, if this regulation would increase technology development inequalities between countries. Maybe Hadassah, you can address this.
Yeah, in terms of the enforcement of the EU AI Act, what's interesting is that the European legislators try to take on a centralized approach, as opposed to, for instance, the GDPR, where they took on a decentralized approach, where member state authorities all kind of implemented the GDPR, even though it's a regulation, so it's directly applicable, but it all became a little bit inconsistent. And I think that's also one of the main complaints about this piece of regulation. So they tried to take on a different approach now. And the idea is that by having a centralized approach with authorities in the member states and an EU AI office kind of like coordinating this enforcement scene, that won't be the case. So the idea is, no, if that is going to happen in practice, it really depends on, first of all, I think the resources made available to enforcement, and I think also the political willingness of member states to ensure harmonization. Because at the end of the day, the idea of regulation in the EU is harmonization across member states, and also to ensure that when we're talking about collaboration abroad, or for instance, in relation to the United States or other countries, that there's like a consistent approach to the act. If that's going to be the case, again, like I love how my response is we don't know, but we really don't know what's going to happen. I missed the second question that you asked, Krystal.
Yeah, the second question is how does regulation will impact on the inequalities in terms of technology development between countries, if any?
Yes, I think that the stringency of the regulation plays an important part here. I think that in terms of looking at the goal of the EU AI Act is to foster innovation, right? And to ensure that the risks are mitigated. I think it is departing from an approach, but maybe others disagree, of an environment of a part of the globe that is, running at the forefront of technological development. So I also wonder what the impact is going to be across the globe in countries that are less developed in terms of technology. I think in the EU it may be fitting. I think in the US it may be fitting. I think in the global West it may be fitting. But when you look at other countries, I don't know if that's going to have the same impact.
If I may jump into this inequality question, I think if we draw from prior waves of innovation, what typically happens in less developed countries is that they are just looking to capitalize, right? The questions about safety and security, they come in later, because in the end, they're just trying to develop their industry and they're trying to foster an environment from the policy side of the house, like the regulatory side of the house. It's like, how do we foster more innovation within our country so that we can catch up or leapfrog? And while the intentions are there to do that responsibly, many times the calculus is just very simply very different. And so if you're thinking about companies that are looking to, for example, deploy their models in the EU, I think absolutely that may be a barrier. But then again, if there is enough value assigned to having AI governance be a differentiator, where people are willing to either pay more for a product or service, or are willing to be more loyal to a certain brand because they've decided to invest in this. That is something that we have seen in other sectors, perhaps not at the scale that we would want to. But yeah, there's definitely something that will need to be done in order to ensure that other developers and deployers outside of the main developed countries are also seeing value in adopting some of these practices.
Yeah, I mean, I think that the challenge is, and it's true in both lesser developed countries and quite honestly, for small businesses in these countries, right, is that the costs are going to go up to do business, the cost of doing business, because much like the cost in acting in a regulated industry is higher than in a non-regulated industry. So if you want to do healthcare applications, there's a higher cost because your regulatory burden is higher. If you want to do financial services, there's a higher cost because your regulatory burden is higher. What this is doing, and again, you could argue the merits of it, but it's the practical impact, which is it's going to increase the cost for small businesses or lesser developed countries to deploy and use AI. It just is. And there may be really good reasons for that, but that's the practical impact.
That leads to our last question today. What advice or best practices that you guys have for companies, big or small, to be more engaged in this AI lawmaking process and also trying to be compliant? Any technology that they can use in this process? Maybe we'll start with Adam.
Sure. I mean, look, at the end of the day, I anchor back to this principle like we have in the United States, which is as long as you take the approach that this technology is just an enabling technology, like any other enabling, and you're responsible for its use, then it shouldn't be any different than anything else, right? So again, if you're in healthcare, it can't discriminate. It needs to keep things private, right? If you're in consumer finance, again, can't discriminate. Real estate, all these sorts of things, right? You just need to look at it and just not blindly use it as just a tool that you can use unfettered. You're responsible for its output, whether that's as simple as a chatbot or more complex in terms of a diagnostic. It's like if you were doing it manually. And if you take that approach and put the right policies and procedures and protections and guardrails, whether technical or otherwise, in place, you'll probably be fine. But if you don't, you're taking a huge risk because the spotlight will be on you when mistakes are made.
Lucía, anything you want to add there? And Hadassah?
Yeah, I mean, I will say that in the end, you need to start investing in a risk management system, right? And you do not need to wait for regulation. There are common elements like registering your AI use cases that you can begin to do that relatively easily. There's a lot of frameworks out there, like the NIST risk management framework, for example, that are low cost options or zero cost options that already provide a framework and a roadmap. That being said, you are going to need to train individuals in your organization to implement these things. And so just upfronting those costs. And there's a lot of solutions out there, including Credo AI, that will help you do that, right? Regardless of the size or the industry that you're in. But we're seeing just the whole industry come out of this space just because it is complicated and it does require a certain investment.
Yeah, I would add to just one thing. I'm a big fan of the design thinking process, and one of the elements within that is the concept or the practice of iteration, right? So when we look at this scene and we look at the need to comply with upcoming legislation, the reality is it's not going to be perfect. If it's perfect, great. If you're doing a perfect job, amazing. But the intention, like I mentioned earlier, the intention needs to be there. And like Lucía just said, there are many organizations that help out with this. Also, we at the Responsible AI Institute offer tools that organizations can use based on all these frameworks from the EU to the US and globally to understand what can you do in practice to make sure that what you are developing, what you are deploying, what you're using, what systems, that you're doing so in a responsible way. Basically providing a roadmap. That's essentially what we do. And to understand where are we standing right now, which is very important, where do we want to head next? And like I mentioned earlier, this compliance scene shouldn't become a check the box exercise. Compliance is super important, but I think even more than that, perhaps, and what I would like to think this regulatory scene is trying to create is trust. Trust for organizations developing, deploying, and using these systems. And I think if anything, that is also a value that is core to businesses as well. So I think that's how I would, or takeaway that I would want to share.
Yep, that's very helpful. And on that note, it's a wrap for our webinar today. I have learned a lot and hope you do too. Thanks again for our great panelists for bringing perspectives on the EU AI Act from the area that they practice in. And thanks for the audience who joined us from all over the world. I believe Responsible AI will host more series like this to discuss issues in AI regulations. So thanks again for everyone joining us.